All rise. Veuillez vous lever. The International Criminal Court is now in session. L'audience pénale de cour est ouverte. Veuillez please be seated. Veuillez vous asseoir.
Good morning, everyone. I would like to welcome you to the courtroom in this new case, and I would like the court officer to call the case.
Good morning, Mr. President and Your Honors. Situation in the Central African Republic 2. In the case of the prosecutor versus Alfred Yekatom and Patrice Edouard Ngai ssona, case reference ICC 0114-0118, and for the record, we are in open session.
Thank you. I would like to take the appearances. First, the prosecution.
Good morning, Mr. President, Your Honors. Good morning, everyone. Today, the prosecution is represented by Olivia Stralvin, seated behind me, and Yassine Mostfa, seated ahead of me. My name is Kweku Vanderpoel. Good morning once again.
I understand that there might be a rotating presence from the prosecution.
Indeed, Mr. President, because of the situation concerning the pandemic.
Thank you. And then the victims' representatives, please.
Good morning, Mr. President, Your Honors. Les victimes des autres crimes sont représentées.
Other crimes are represented today by a team of lawyers. Here, I'm going to be here, Paulina Masida, with my colleague Elizabeth Radasana-Tada. Linked to Senegal, our colleague Maître Yari Fall. And linked in Bangui in the Central African Republic, our counsel Tima Lawson and Adangabo Usa Abdul. Thank you.
Thank you. Please.
Good morning, Mr. President. Good morning, Your Honors. The former child soldiers are represented by myself, Dmitry Supron, counsel at the Office of Public Counsel for Victims.
Thank you. And now we turn to the defense. Ms. Dmitry.
Good morning, Mr. President. Good morning, Your Honors. Good morning, my colleagues. Mr. Yekatom this morning is represented by Mr. Tom Hannis, Associate Counsel, to my left. Ms. Sabrine Beissa, Case Manager, behind me. We have in the public gallery Ms. Lena Cazier, Legal Assistant, Ms. Wilhelmina Whittingham, and in the course of the week, I hope I'll get a chance to introduce the other team members of Mr. Yekatom, and there's myself, Ms. Milan Dimitri, Lead Counsel.
Thank you. Mr. Knops. Microphone, please, Mr. Knops.
Good morning, Mr. President, Your Honors. Good morning, colleagues. The defendant, Mr. Ssona, is today represented by my associate counsel, Mr. Richard Omessi Landry Namkemai, new co-counsel. On my left side, Ms. Sarah Pedroso, legal assistant. Thank you.
Welcome, Mr. Omise. You are new to the court, and we welcome you here in the courtroom. And we have also to introduce the judges, the bench for this case. To my right is Judge Peter Kovac. To my left is Judge Chang Ho Chung, and I'm Judge Bertram Schmidt. For the information of the public, the Chamber notes that several restrictions apply to today's hearing in light, as we all know, of the COVID-19 pandemic. In particular, the participants, parties registry and chambers staff appear only with a limited team to reduce the risks, but this is, of course, self-explanatory. And additionally, several measures are being taken to ensure appropriate distancing in the courtroom. Short information on schedule and publicity. Pursuant to the information provided by the registry, in consultation with the crisis management team, the Chamber is glad to announce that the hearings can be held pursuant to the normal hearing schedule. Accordingly, the opening statements will be heard in 3 sessions, normally from 9:30 to 11, 11:30 to 1 o'clock, and 2 o'clock in the afternoon until 3:30. When I say normally, the parties and participants are aware that we might have perhaps an earlier break today. Mr. Knops, you know, perhaps we will indicate when you have to leave. In light of the time granted to the participants and parties to make their respective presentations, the Chamber anticipates that the opening statements will be finished on Thursday, 11th February, and the ssona defense is assured that they can have their presentation on Thursday and not earlier. The Chamber notes that this hearing is held in open session unless a request to do otherwise is made by the participants or the registry. Before the charges are read and we hear the opening statements, I would like to briefly recall, really briefly, the background of this case. On 30th May 2014, the government of the Central African Republic referred to the prosecution of the court the situation in its territory since 1st August 2012, the so-called CAR2 situation. At the request of the prosecution, Pretrial Chamber 2 issued warrants of arrest against Mr. Alfred Yekatom and Mr. Patrice Edouard Ngai on 11th November 2018 and 7th December 2018, respectively. Mr. Yekatom was transferred to the court on 17th November 2018. Mr. Ngai was transferred to the court on 23rd January 2019. The charges brought by the prosecution against the 2 accused were confirmed, in part, by Pretrial Chamber 2 on 11th December 2019. In accordance with Article 64, paragraph 8a of the statute, the charges will now be read to the accused. The accused will then be afforded the opportunity to make an admission of guilt or plead not guilty. The court officer will read extracts of the confirmed charges as instructed in the initial directions on the conduct of the proceedings. Due to the public nature of this hearing, these extracts are based on the public redacted version of the decision on the confirmation of charges. Counsel, I trust that you have no objections to this approach. Mr. van der Poeje, is there a problem with that?
None, Mr. President.
Ms. Dimitri?
No objection, Mr. President.
Mr. Knops?
No objection, Mr. President. Thank you.
The Chamber stresses in this context that these redacted portions are only redacted from the public, of course. The accused and their respective defense teams are fully aware of the details behind these redactions by virtue of the confidential decision. They have received the unredacted version of the confirmation decision in French, a language they fully understand. This is correct, Ms. Dimitri?
That's correct, Mr. President.
Mr. Knops?
That is correct, Mr. President.
Then we can proceed to the reading of the charges. Court officer, please proceed.
Charges. Alfred Yekatom, a national of the Central African Republic, born on 23 January 1975 in Bimbo, the Central African Republic, also known as Alfred Saragba, Rombot, Rambo, Rambot, Rombot, Rombot, Rombo, or Romboth, is criminally responsible for the war crimes of 1. Directing attacks against the civilian population in Bangui, including Katyn and the Boyne Market, starting on 5 December 2013, on the basis of the conduct pertaining to counts 2 to 6 and 8. 2. Mora, 4A, the killing of between 5 and 13 persons, redacted, at the Boyne Market for Muslim persons in Katyn and redacted, at the Boyne Market in the context of the attack on Bangui, including Katyn and Boyne on 5 December 2013. B. Redacted. at the Yambara school base, redacted. C, the killing of Deputy Mayor Saleh on or about 28 February 2014 in Mbaiki, in the context of the anti-Balaka's advance through and takeover of villages along the PK9 and Mbaiki axis, including Sekia, Ndangala, Vimon, Kapu, Bosongo, Pisa, and Mbaiki, count 27. 3. Displacement. 4. A. The dislocation of nearly all Muslim persons residing in Katin and Boyne to PK5, a predominantly Muslim neighborhood in Banki, other parts of the Central African Republic, or neighboring countries. Starting from 5 December 2013, in the context of the attack on Bangui, including Katin and Boyne on 5 December 2013, count 5. B, the dislocation of the majority of the Muslim population from their towns and villages between on or about 10 January 2014 and or about 6 February 2014, in the context of the anti-Balaka's advance through and takeover of villages along the PK9 and Mbaiki axis, including Sekia, Ndangala, Vimon, Kapu, Bosongo, Pisa, and Mbaiki, count 25. 4. Directing an attack against a building dedicated to religion for the destruction of the Boyne Mosque by 20 December 2013 at the latest, count 6. 5. Cruel treatment for the redacted, the Yambara school base, redacted, count 13. 6. Torture for the redacted, the Yambara school base, redacted, count 13. 7. Conscription, enlistment and use of children under the age of 15 years to participate actively in hostilities, for the conscription and or enlistment of children into his group at various locations, including, redacted, at the assignment of a variety of tasks to them, such as, inter alia, participating in hostilities, including the 5 December 2013 attack, between at least December 2013 and August 2014, count 29. All committed in the context of an associated with an armed conflict not of an international character, ongoing in the territory of the Central African Republic from September 2013 until at least December 2014, between the Seleka and the Anti-Balaka, including Yekatom's group. Yekatom is also criminally responsible for the crimes against humanity of 1. Murder. A. The killing of between 5 and 13 persons, redacted, at the Boyne market for Muslim persons in Katin, and redacted, at the Boyne market in the context of the attack on Bangui, including Katin and Boyne on 5 December 2013, count 2. B. Redacted, at the Yambara school base, count 15. C. The killing of Deputy Mayor Saleh on or about 28 February 2014 in Mbaiki, in the context of the anti-Balaka's advance through and takeover of villages along the PK9 and Mbaiki axis, including Sekia, Ndangala, Bimon, Kapu, Bosongo, Pisa, and Mbaiki, count 26. 2. Forcible transfer and deportation. 4. A. Dislocation of nearly all Muslim persons residing in Katin and Boyne to PK5, and predominantly Muslim neighborhood in Banki, other parts of the Central African Republic, or neighboring countries, starting from 5 December 2013 in the context of the attack on Bangui, including Katin and Boeing on 5 December 2013, count 4. B, the dislocation of the majority of the Muslim population from their towns and villages between on or about 10 January 2014 and or about 6 February 2014 in the context of the anti-Balaka's advance through and takeover of villages along the PK9 and Baki axis, including Sequia, Ndangala, Bimon, Capu, Bosongo, Pisa, and Baiki. Count 24. 3. Other inhumane acts. For the redacted, the Yambara school base, redacted, count 11. 4. Torture. For the redacted, Yambara school base, redacted, count 12. 5. Imprisonment and other forms of severe deprivation of physical liberty. Or the redacted, the Yambara school base, redacted, count 14. 6. Persecution. For the severe deprivation of the fundamental rights of persons in Bangui, including Katin, Boeing, and Yambara school base, and the villages along the PK9 and Baki axis, by targeting them on the basis of political, ethnic, and religious grounds, by virtue of the conduct pertaining to counts 1 to 7, 11 to 16, 24 to 27, counts 8, 17, 28. All committed as part of a widespread attack conducted by the anti-Balaka, including Yekatom's group, between September 2013 and December 2014 against the Muslim civilian population and those perceived as collectively responsible for complicit with or supportive of the Seleka, pursuant to or in furtherance of a criminal policy to primarily target the Muslim population in Bangui and in Western Central African Republic prefectures in retribution for Seleka exactions. Yekatom's contribution to the charged crimes consist in 1. Instructing, training, and equipping his anti-Balaka elements. 2. Preparing the anti-Balaka attacks and advances and participating and leading his group in the execution of these attacks and advances. 3. Issuing orders to anti-Balaka members, including patently illegal instructions. And 4. Conscripting and or enlisting children under the age of 15 years into his group and using them to assist him in the camp bases, giving orders for them to be stationed at barriers and checkpoints, as well as to actively participate in hostilities. Accordingly, Yekatom is criminally responsible under the following modes of liability. 1. Committing the affirmation crimes jointly with another or through another. Or 2. Ordering the commission of the affirmation crimes. Patrice Edouard Ngai, a national of the Central African Republic, born on 30 June 1967 in Bewa, the Central African Republic, is criminally responsible for the war crimes of 1. Directing attacks against the civilian population at the following locations and times. A. In Bangui, including Katin and the Boeing Market, starting on 5 December 2013 on the basis of the conduct pertaining to counts 2 to 6 and 8. Count 1. B. In Bosongo, on 5 December 2013, approximately from 13 hours to between 17 and 18:30 hours, on the basis of the conduct pertaining to counts 31 to 33, 35, 37, and 39 to 42. Count 30. 2. murder. 4. A. The killing of between 5 and 13 persons, including redacted at the Voin Market for Muslim persons in Katin, and redacted at the Voin Market in the context of the attack on Bangui, including Katin and Voin, on 5 December 2013, count 3. B. The killing of 28 persons, redacted, in the context of the attack on Bosongwa on 5 December 2013, count 32. C. Redacted at the Yambara school base, redacted, count 16. D. The killing of Deputy Mayor Saleh on or about 28 February 2014 in Mbaiki, in the context of the anti-Balaka's advance through and takeover of villages along the PK9 and Mbaiki axis, including Sekia, Ndangala, Vimon, Kapu, Bozongo, Pisa, and Baiki, count 27. 3. Displacement 4. A. The dislocation of nearly all Muslim persons residing in Katin and Voin to PK5. A predominantly Muslim neighborhood in Bangui, other parts of Central African Republic, or neighboring countries, starting from 5 December 2013, in the context of the attack on Bangui, including Katin and Voin on 5 December 2013, count 5. B. The dislocation of Bosangwa's Muslim population to the École de la Liberté before being evacuated to other locations in the context of the attack on Bosangwa on 5 December 2013 and in the days following the attack, count 38. C. The dislocation of the majority of the Muslim population from their towns and villages between or about 10 January 2014 and on or about 6 February 2014 in the context of the anti-Balaka's advance through and takeover of the villages along the PK9 and Baiki axis, including Sekia, Ndangala, Bimon, Kapu, Bosongo, Pisa, and Baiki, count 25. 4. Directing attacks against buildings dedicated to religion. 4. A. The destruction of the Voin Mosque by 20 December 2013, at least, count 6. B. The destruction of the Central Mosque of Bosongwa in the context of the attack on Bosongwa on 5 December 2013 and in the week following the attack, count 35. 5. Cruel treatment. For the redacted, the Yambara school base, redacted, count 13. 6. Torture. For the redacted, the Yambara school base, redacted, count 13. 7. Destruction of the adversary's property. For the destruction of Muslim houses, especially in predominantly Muslim neighborhoods of Boro, Arab, and Fob, in the context of the attack on Bosongwa on 5 December 2013 and in the days after the attack, count 33. 8. Pillaging. For the pillaging and looting of the houses of Muslims, particularly in the Boro, Arab, and Fob neighborhoods, sometimes writing the words anti-Balaka on the rubble in the context of the attack on Bosongwa on 5 December 2013, count 34. 9. Rape. For the rape of redacted woman in the context of the attack on Bosongwa on 5 December 2013, count 41. All committed in the context of and associated with an armed conflict none of an international character ongoing in the territory of the Central African Republic from September 2013 until at least December 2014 between the Seleka and the Antibalaka, including Yekatom's group. Ngai ssona is also criminally responsible for the crimes against humanity of 1. Murder. 4. A. The killing of between 5 and 13 persons, redacted, at the Boyne Market for Muslim persons in Katyn, and redacted, at the Boyne Market in the context of the attack on Bangui, including Katyn and Boyne on 5 December 2013, count 2. B. The killing of 28 persons, redacted, in the context of the attack on Bosongwa on 5 December 2013, count 31. C. Redacted, at the Yambara school base, redacted, count 15. D. The killing of Deputy Mayor Saleh on or about 28 February 2014 in Mbaiki in the context of the anti-Balaka's advance through and the takeover of villages along the PK9 and Mbaiki axis, including Sekia, Ndangala, Bimon, Kapu, Bozongo, Pisa, and Baiki, count 26. 2. Forcible transfer and deportation. 4. A. The dislocation of nearly all Muslim persons residing in Katyn and Boyne to PK5, a predominantly Muslim neighborhood in Bangui or other parts of the Central African Republic or neighboring countries, starting from 5 December 2013 in the context of the attack on Bangui, including Katyn and Boyne on 5 December 2013, count 4. B. The dislocation of Bosongwa's Muslim population to the École de la Liberté before being evacuated to other locations in the context of the attack on Bosongwa on 5 December 2013 and in the days following the attack. Count 37. C. The dislocation of the majority of the Muslim population from their towns and villages between on or about 10 January 2014 and on or about 6 February 2014 in the context of the anti-Balaka's advance through and takeover of villages along the PK9 and Baiki axis, including Sekia, Ndangala, Bimon, Kapu, Bosongwa, Pisa, and Baiki, count 24. 3. Other inhumane acts. 4. Redacted. The Yamvara school base, redacted, count 11. 4. Torture. 4. Redacted. The Yamvara school base, count 12. 5. Imprisonment and other forms of severe deprivation of physical liberty. 4. A. The redacted, the Yambara school base, count 13. B. Maintaining the Muslim at the École de la Liberté by preventing them from leaving, including by shooting threats towards the families inside the compound in the context of the attack on Bosongwa on 5 December 2013 and the weeks following the attack, count 39. 6. Rape. For the rape of a redacted woman in the context of the attack on Bosongwa on 5 December 2013, count 40. 7. Persecution. For the severe deprivation of fundamental rights of persons in Bangui, including Katyn and Boyne, Bosongwa, the Yambara school base, and villages along the PK9 and Baiki axis of their fundamental rights by targeting them on the basis of political, ethnic, and/or religious grounds by virtue of the conduct pertaining to counts 1 to 7, 11 to 16, 24 to 27, 30 to 41, counts 8, 17, 28, 42. All committed as part of a widespread attack carried out by the Anti-Balaka, including Yekatom's group, between September 2013 and December 2014 against the civilian population and those perceived as collectively responsible for, complicit with, or supportive of the Seleka, pursuant to or in furtherance of a criminal policy to primarily target the Muslim population in Bangui and in Western Central African Republic prefectures in retribution for Seleka its actions. Ngaisona's contribution to the charged crimes consists in 1. Taking steps to structure the Anti-Balaka. 2. Financing the Anti-Balaka, including for the purchase of weapons. 3. Issuing instructions to Anti-Balaka members, including with regard to the 5 December 2013 attack and attacks preceding it. And 4. Liaising with Anti-Balaka members exercising key functions, including redacted. Accordingly, Ngaisona is criminally responsible under the following modes of liability. 1. Facilitating the commission of the crimes as set out in the confirmed charges by aiding, abetting, and otherwise assisting in their commission. Or 2. Contributing in any other way to the commission of those crimes by a group of persons acting with a common purpose. Thank you.
Thank you very much. Mr. Yekatom, please rise. Mr. Yekatom, would you please rise? Mr. Yekatom, I trust that you understand the nature of the charges brought against you. Is this correct?
Bima teneso ala binando timbi membi keteneni na kurugo.
Yes, I have understood everything that has been said here.
Yeah, thank you.
And I categorically say that these counts are not correct.
So if you say you categorically...
I reject all the charges that you have laid against me.
So I take it, Ms. Dimitri and Mr. Yekatom, that is a plead not guilty to the confirmed charges.
Yes, Mr. President.
Okay, thank you. Mr. Ngai ssona, please rise. Mr. Ngai ssona, I ask you the same question. I trust that you understand the nature of the charges brought against you. Is this correct?
Votre honneur, Monsieur le Président.
Mr. President, Your Honor, I've closely followed what you've been saying. Ngasa Motene.
Je vous remercie. Je suis non coupable.
I didn't receive a translation here.
You have to have pauses in order to enable interpretation to take place. Otherwise, there's an overlapping.
Yes, that might be, but Mr. Ngai ssona has said something, and we would like to hear what he has said. Obviously, this seems not to be possible, Mr. Ngai ssona. I have to apologize for that. Could you please again answer my question if you understand the nature of the charges?
Monsieur le Président,
Mr. President, I repeat,
je me reconnais.
I
Je me reconnais
have
pas dans l'accusation portée contre
don't
moi.
recognize myself in the charges brought against me. I am not guilty.
But you understand what has been said, what is brought against you, and you say you are not guilty. Is this correctly summarized?
Jimani. J'ai bien écouté, j'ai bien entendu.
I've heard what has been said, Mr. President.
Thank you. Mr. Knops, I think we can take it that your client confirms that he understood the charges, the nature of the charges. We know that this is not the legal characterization, everything in detail, and that he pleads not guilty. Is this a correct summary by me?
Yes, Mr. President, Mr. Ssona pleads not guilty to all charges. And he understands the charges perfectly. Thank you.
Thank you very much. The Chamber will now hear the opening statements. I think it's a good idea to have a short break here. Or Mr. Knops, what would you say?
Very kind, Mr. President. You alert to this situation, but I'm able to follow the first part till 10:45. If that's
then we
convenient for the court.
then we continue first with another procedural matter, and then we go on to the opening statements. Thank you very much, Mr. Knops.
Thank you.
In its decision 589, the Chamber set a deadline of 11th January 2021 for the filing of any motions requiring resolution prior to the commencement of the trial. According to Rule 134, paragraph 2 of the rules, I ask the prosecution and the defense whether there are any remaining objections or observations concerning the conduct of the proceedings which have arisen since the confirmation hearing. Mr. van der Poeje.
Thank you, Mr. President. There are no objections with respect to the conduct of proceedings. There is one matter, though, and that has to deal with a procedural issue concerning the provision of binders and things like that, which I wanted to bring to the Chamber's attention, but otherwise nothing.
This is something that the judges have to reflect on, and especially the presiding judge, who is from an analog generation. I have to think about it, simply.
Thank you, Mr.
I understand what you mean. Ms. Dimitri?
Thank you, Mr. President. If I may, I have 3 observations. My first observations, Mr. President, Your Honor, is in relation to disclosure. We have outstanding disclosure requests. However, I do not intend to file any motion at this stage, nor request any ruling from Your Honors. I reached an agreement with the prosecution yesterday. The prosecution gave me their word that all pending disclosure requests will be addressed in the following days, and at the latest by 25th of February. If this is not the case, which I doubt, I will address the Chamber by that time, with your leave. My second observation, Mr. President, concerns redactions. You will recall, Your Honors will recall that in the Yekatom defense submission for the first status conference in filing 472, we requested the Chamber to set a firm deadline for the prosecution to lift all redactions applied for lead and sources, A6.1. While the Chamber did not specifically address the redactions for lead and sources in the aftermath of the first status conference, it nevertheless recalled in the decision for the protocols at trial, the decision 677, that the disclosing party's burden of justifying the redactions and the disclosing party's ongoing obligations to review the redactions applied to ensure that they remain justified. Given that the Chamber reminded the prosecution that its investigation should have been largely completed at the stage of the confirmation hearing, we respectfully submit that all lead and sources, A6.1 redactions, should be lifted now that the trial is starting. So we are again respectfully asking the chamber to set a firm deadline for those to be lifted, rather than having the prosecution lifting them on a rolling basis as the witness appear prior to their testimony. Finally, my last observations, Mr. President, Your Honors, is in relation to dual status witnesses. We understand the Chamber's direction on the procedure for the disclosure of the application forms for dual status individuals in its decision on the protocols at trial, and in particular the dual status protocol. However, I am afraid that somehow the manner in which the information is communicated once a decision is issued by the Chamber on participating victims might have the unfortunate consequence that the defense loses track of the number of dual status witnesses and the disclosure of their application form. In other words, it's impossible for me to cross-check who has been authorized to participate with the P numbers of the prosecution witnesses in order to make sure that the application forms have been disclosed by the prosecution in their redacted form. I had a discussion with my learned friend, Ms. Masida, yesterday, and according to her, 5 victims of other crimes have been authorized to participate: P1666, P1676, P2324, P2353, and P2354. However, I believe I only received, unless I'm mistaken, disclosure for 3 of them, 3 application forms. Had I not spoken to Ms. Masida, I would have no way of finding out that some participating forms were missing. So I'm just respectfully requesting the Chamber to perhaps review the chain of communication when a decision on participating victims is issued, in order to include the defense, for me to be able to keep track of the disclosure of the application forms. This is a particular case because your honors will recall that you authorized the victims to participate until the end of the prosecution's case, until the end of the presentation of their case. So this marks the end of my observations, Mr. President. Thank you.
Thank you very much. Your observations are duly noted, and one addressee would have been Ms. Masida. I don't ask you now because we are in the opening stage. If you can solve the problem, so to speak, that Ms. Dimitri has, the Chamber would appreciate it, because the less intervention the Chamber needs to make, the better. And the same applies, of course, always to the prosecution too.
Thank you, Mr. President. I think I can already address very briefly that if the Chamber authorizes, once the Chamber issue any decision on victims' participation, then we can immediately check if in that decision we identify the dual status, and we can provide the list to the parties and participants. This, I think, should solve the issue.
I hear you, and I see a nodding on the side of Ms. Dimitri, so this should indeed solve the issue. Thank you very much.
Welcome.
Mr. Knops, it's your turn.
No specific observations, Mr. President, on the conduct of proceedings, but it might be suggested that the Chamber also reflects on, once the witnesses are appearing, on the permissibility of leading questions in the examination in chief, which was one of the discussions in my previous trial before this bench. It's not to answer this question now, but it seems to me that in the conduct of proceedings, this element, the mode of questioning, is left open yet, and it might help the parties to receive from the Chamber instructions as to the permissibility of leading questions during the examination in chief and or cross-examination. Thank you.
Thank you, Mr. Knops. This was deliberately left out because this Chamber is not happy with 2 strict rules here. I think this will simply be established a practice here in the courtroom. What is allowed, the Chamber will not say that leading questions are in generally not allowed. I can, if you want, I can already elaborate a little bit why, perhaps 2 or 3 phrases, and that's it. We have this, in principle, the evidence is presented by parties, so we have in principle here, at least what the structure, if you look at the structure of the proceedings at the ICC, we have a party-driven process. prosecution, defense, victims present their evidence. They call witnesses. They are not their witnesses, they are witnesses of the court in there, but they call the witnesses. And so we follow, in principle, sort of a common law procedure in that regard. And essential to a common law procedure is that the calling party, what is then called direct examination, can use some sort of leading questions. And the chamber will tolerate that as long as the witnesses seem not to be harassed, intimidated, or what happened in other cases. What I can recall is that sometimes they didn't understand the language of this questioning. So we will be vigilant in that regard, but we will not, so to speak, prohibit it from the outset, because it seems to be something that is entailed in the structure of these proceedings. I can imagine that you would feel quite comfortable with this solution. I simply assume it. So I think we will not have huge discussions on that. That's for the moment. Yeah? Okay. Thank you, Mr. Knops. And now the chamber will hear the opening statements. We first hear from the prosecution, as indicated, followed by the common legal representatives of victims and the ssona defense. The ssona defense, as I said, on Thursday. The Yekatom defense will present its opening statements at the beginning of its evidence presentation. As per the initial directions, the prosecution has 6 hours for its opening statements. The CLREs have 3 hours to be divided amongst them, and the ssona defense has 3 hours. I don't know who will start. Mr. van der Pooijen, I would assume. Yeah, you have the floor. To explain the discussion here also, it's Mr. Knops has indicated that he can stay a little bit longer, and I think we should really accommodate that as long as he's able to follow us, that he can also hear what the prosecution is going to say, and then we will have a short break.
Just bear with us one moment, Mr. President. I'm just about to get started.
No problem. This will be very technical, and I understand that this might take some time, and we have to be indulgent with each other, I think.
Mr. President and parties and participants, please be aware that the presentation will be displayed in evidence too. Thank you.
Good morning, Mr. President, Your Honors, everyone. It's my privilege to appear before you once again on behalf of the prosecution and of my team. I'll begin with just a few words in French for the interpreters. Monsieur le Président,
Mr. President, Your Honors, this day, the beginning of the process of Alfred Yekatom and Ngai, is an important day for justice. It shows the determination of the court to fight against impunity and our commitment towards the victims who suffered atrocities during that period and the criminal situation which took place in that country during the transition. I would like to stress that this process against the Antipalaka is only a first step. Our proceedings will be initiated and other cases will continue, tracking down those responsible for serious crimes in the Central African Republic. The arrest of Mohamed Said Abdel Khani for causes against humanity and war crimes is a witness to the activities of the prosecution in this sense. Our investigations are underway. Justice is necessary for peace and the reconstruction of the Central African Republic. Impunity cannot be an option. Only the systematic conviction of these crimes and abuses will help protect the civilian population. Only the recognitions and reputation for victims for what they have subjected and continue to face must be broken so that this circle of retaliation comes to an end. Mr. President, Your Honours, with your permission, I shall now continue in English.
Your Honours, when the transition government of the Central African Republic referred this situation to the Office of the Prosecutor, it did so in the hopes of achieving justice for thousands of innocent civilians decimated by protracted violence, victims of horrible crimes and atrocities. The Office of the Prosecutor applied for and received authorization to investigate alleged violations of the Rome Statute in September 2014, as you noted. And we are here today as a product of a long and difficult investigation, but one aimed to establish the truth regarding the charged crimes. We're here today because of the commitment and resolve of the people of the Central African Republic, because of our collective commitment to the principles of the Rome Statute, and importantly, its mandate to hold to account those responsible for the most serious crimes of concern to the international community as a whole on all sides of the CAR conflict. We begin that process today with this case as our investigations in the situation continue. The violence and instability in the Central African Republic since its independence never truly divided its people. Although elusive for many complex reasons, they have always persisted in their pursuit of peace. And we're here as a result of that. The crimes that are charged in this case violate the Rome Statute and well-established norms and customs of war. The events are shocking to the conscience and so arresting in scale that they transgress the very nature of our humanity. Mr. President, Your Honors, the victims of the Central African Republic conflict deserve to be seen, they deserve to be heard, and they deserve their day in court. Justice must prevail. And the evidence in this case will establish the individual criminal responsibility of Patrice Edouard Ngai and Alfred Yekatom for crimes against humanity and war crimes in violation of Articles 7 and 8 of the Rome Statute, as confirmed by Pretrial Chamber 2 on the 11th of December 2019. Briefly, from about June 2013, Ngai, General Francois Bozizé, the former president of the Central African Republic, Bernard Mokom, Maxime Mokom, and others implemented a strategy, a plan, designed to reclaim political power in CAR following the Seleka's ouster of Bozizé in a coup d'etat on the 24th of March 2013. Ngai ssona was a member of Bozizé's inner circle. He helped put together a fighting force composed, among others, of members of Bozizé's former presidential guard, members of the Forces Armées Centrafricaines, which I'll refer to as the FACA, pre-existing self-defense groups, new recruits, and others to forcibly remove the incumbent Seleka regime. While the objective of their strategy was to reclaim power, the means, the consequences, well, unfortunately, that's why we're here. As the evidence will show, Ngai ssona's participation in this strategy was integral, and he contributed to it fully aware that the group he was helping to structure, arm, finance, instruct, and organize, known by September 2013 as the Anti-Balaka, would inevitably target the Muslim civilian population in Western CAR. He knew the vengeance within them, and he knew that they intended to and would commit the multiple acts and crimes constituting the widespread and systematic attack that took place from September 2013 through December 2014. This attack included the seminal coordinated anti-Balaka offensives of 5 December 2013 at Bangui and Bosangoa, hundreds of kilometers apart. As the pretrial chamber noted, and the evidence before you will prove beyond reasonable doubt, the attack, quote, the attack on Bosangoa and the 5 December 2013 attack on Bangui were essential components of the strategy to reclaim power by Francois Bozizé and others. I'll repeat that. They were essential components of the strategy to reclaim power by Francois Bozizé and others. Ngai ssona was a principal in the Anti-Balaka before he was designated the group's national coordinator in January 2014, its chief. He was its de facto political coordinator. Maxime Mokom was its coordinator for military operations. His father, Bernard Mokom, as you will hear, was also influential in the group's leadership. From its inception, Ngai ssona was aware of the Anti-Balaka's organizational policy. That policy entailed violent targeting of Muslim civilians in Western CAR, who, based on their religious, national, or ethnic affiliation, were perceived as collectively responsible for, complicit with, and supportive of the Seleka. You will hear this referred to as the criminal policy or common purpose in our presentation. Ngai ssona's many contributions collectively promoted and encouraged the establishment, implementation, and perpetuation of the Anti-Balaka's common purpose. A common purpose which cut across the charged crimes and the multiple acts forming the widespread and systematic attack of which they were a part. I will detail some of those incidents toward the end of my submissions, but his contributions enhanced the capacity of the Anti-Balaka to commit the charged crimes, their preparedness to commit those crimes, and their willingness to do so. Alfred Yekatom, having fled CAR upon Bozizé's overthrow, amassed and commanded a group of some 3,000 fighters, elements. A former caporal-chef in the FACA turned senior and powerful Anti-Balaka zone commander, Yekatom trained, structured, and armed his elements. He prepared, planned, and led them in crimes as a key part of the Anti-Balaka's widespread attack. He did this with elements under his command in the areas under his responsibility, in and around Bangui and in the Lobai prefecture, the so-called Zone Sud. He did that pursuant to the same common purpose. Yekatom and as many as 1,500 of his elements participated in the coordinated 5 December 2013 attack on Bangui. They committed serious crimes in its adjacent neighborhoods and in its aftermath, continued to commit crimes in Boeing and along the PK9 and Baiki axis through 28 February 2014. Yekatom is charged with these crimes, including the expulsion of Muslim civilians en masse, murder, torture, cruel treatment, as well as for enlisting and conscripting and using children under age 15 in hostilities from at least December 2013 through August of 2014. The evidence in this case will establish Ngaisona's and Yekatom's criminal responsibility beyond any reasonable doubt. And it will show that Ngaisona bears criminal responsibility for his complicity in anti-Balaka crimes committed in the course of its attacks on Bangui and Bosangoa on the 5th of December 2013 and in their aftermaths, including the crimes that are committed by Yekatom and his elements. The evidence will show that Yekatom bears criminal responsibility for ordering crimes and committing them by, through, and with his anti-Balaka elements in the course of the 5 December 2013 attack on Bangui and in its aftermath, and crimes committed in the Lobai prefecture in furtherance of the anti-Balaka's common purpose. I see I've got about 5 minutes left, so I'm going to just briefly outline our structure, if that's all right, Mr. President.
That's perfect, yeah.
Okay.
We appreciate it.
Today and tomorrow, Mr. President, Your Honors, our presentation will comprise the following. I'll present an overview of the context in which the charged crimes took place. I'll describe the origins of the anti-Balaka and the sense of victimization which transcended its ranks, and how a sense of profound betrayal in the context of Seleka atrocities fueled anti-Muslim sentiment and vengeance against Muslims. And I'll describe how that outrage against the Seleka transformed into a policy which brought destruction and tragedy to the Muslim civilian population throughout Western CAR. I'll explain the strategy used by Bozizé and his inner circle and the implementation of that strategy through anti-Balaka leaders and commanders acting pursuant to the criminal policy in their zones of responsibility. And that, of course, includes Yekatom. I'll cover evidence regarding the contextual elements of war crimes and crimes against humanity. And I will outline the evidence on the widespread and systematic attack against the Muslim civilian population. That includes incidents in CAR's western provinces which formed a part of that attack. My colleagues will provide further detail. Ms. Straven will describe the evidence on the modes of liability and the criminal responsibility of Ngaisona for the charged crimes. Mr. Iverson will describe the evidence on the modes of liability and criminal responsibility of Yekatom for the crimes with which he is charged. Mr. Leddy will outline the evidence on the crimes charged concerning the attack on Bangui, Boeing, and the Yamwara school base incident. Ms. Henderson will outline the evidence on the crimes charged concerning the attack on Bosangoa and its aftermath. And Ms. Berdinikova will outline the evidence on the crimes concerning the PK9 and Baiki axis in Lobai Prefecture, and on the enlistment and conscription of children under the age of 15 and their use in hostilities. I'd just like to clarify a few things about this case, if I may, just before we break. First, this case is about these two individuals. It's about these two men. It's about their personal conduct. It's about what they did and what they didn't do. And it's about whether their conduct amounts to violations of the Rome Statute. Second, this process, this trial, is not a referendum. This case is not about the indictment of one side or another side of the conflict. There's tragedy enough to go all around. The trial is singularly about whether Mr. Ngaisona and Mr. Yekatom bear criminal responsibility for their own actions, for their participation in the commission of crimes in this situation. Third, the accused are presumed innocent. The prosecution bears the burden of proof, and we welcome that. We are confident that the evidence you will hear and see during this trial proves beyond any reasonable doubt that the accused are responsible for the crimes as charged in the decision on the confirmation of charges. Mr. President, I think now's a good time to break, and when we come back, I'll describe some of the evidence that we will present.
Thank you. I think that's indeed a good idea. We'll have a break until 11:15.
All rise.